Hello, everyone. Welcome to the Injured Workers Legal Side with Richard and Paul. I'm Paul, and Richard is a lawyer who specializes in workers' compensation law. Sorry, I'm reading Richard's line because we reversed the roles today. I'm a paralegal that specializes in workers' compensation, human rights, and other things. Richard?
Yes, it's my great honor today to welcome our guest, Bill Scott. Bill's a disability manager for a large construction company, and he's going to give us some of the employer side of the workers' compensation system. And perhaps he could start with some primary concerns with WSIB cases.
Yeah, thanks. Good morning, everyone. So primarily I deal with WSIB claims in Ontario for construction. Um, and I've been doing it for about, I guess I'm in my 18th year now. And quite a shift in the last 6 months to a year of how the board operates, how they treat employers and employees, I'm sure, and workers. It's between return to work, modified duties, their decision making. It's just really hard to get a handle on any type of uniformity with the board, to the point where it can get actually quite frustrating dealing with them, Richard.
What would be sort of a primary concern on a day-to-day basis you'd have with the initial entitlement?
Um, I mean, it's a big animal. I mean, to me, it starts at your own employees. If you have them trained right in incident and injury reporting, that's where it starts. If they don't know the process, this is where it falls apart. If they go outside of the company's reporting protocols and go right to the WSIB, it's basically almost like a free pass for benefits. When the board and injured workers start talking and leaving the employer out, a lot of decisions get made. This is where we're right at the beginning of a claim where we worry a little bit until we get things in place, and we're very quick. We expedite everything, including modified work offers and everything. But that is the number one worry when a worker gets injured, is getting that initial involvement from the employer before the WSIB starts making decisions.
What is the big deal with the modified work offer? In other words, what is going on there and why?
Well, what we try to do, and we have had quite a bit of success in the past with it, is when we find out a worker's injured, we usually get a Form 8, an incident report. That's where we start. We look at the restrictions, obviously, and we talk to the supervisor and we drop a modified job offer, present it to the worker. And then when we file a claim, we know we have the 3 days to file. We like to send a package which includes the Form 7, the Form 8, the incident report, and the modified offer. So right there, it shows anybody on the intake part of it at the WSIB eligibility, whatever you want to call it, that we've already offered modified work. Um, Probably 85% of the time, the injured worker accepts the modified job offer. And then it kind of takes the question of loss of earnings right out of the board's hands. And that's how we prefer to deal with a claim.
What's the financial incentive for employers to be offering modified work so quickly? And is the employer at a loss financially when they offer the modified work?
Yeah, I mean, you're looking at, again, a very large parachute type thing there, or umbrella or branches of a tree, if you think about it. Industry now is obviously looking at people that own construction, that obviously tender out jobs for companies like my company to bid on. They are really looking at things like your lost time injury, your WSIB record. They want a copy of the Wiser report. So they can see lost time, kind of how many injuries you're having. So that's one area where offering modified duty can certainly be financially beneficial to your company. On the other side of things, your actual WSIB premiums, as well as I do, that if you have a terrible record, I believe the financial part of it is they reserve the right to boost your premiums between, what is it, like 1.5% and 3% when calculating your premiums for the next year. That's all on the financial side of it. The modified work, I got into this industry to help injured workers to maintain some form of lifestyle when they are injured. It's unfortunately being lost nowadays. It's become a lot more financial than actually dealing with the injured worker themselves. The claims that I've dealt with over the years, where I used to feel good at the end of a day, now it's more like managing money, and the claims where you really feel like you've helped out are just becoming fewer and fewer for some reason.
Bill, it's funny you say that because I deal a lot with the injured worker side. And I'm very sympathetic to employers, not because, of poor employers, but because the one thing I learned in law is you have to be fair with both sides. If not, the system won't work. And that's why I advocate that if they ever change the workers' compensation system and create a new structure where the board of directors is elected from both sides, it should be equal numbers with a split where the numbers decide the splitting vote, like the president, right? That way they can haggle it out like in court, and it's a fair system. Neither side can say it's unfair. But currently, it's funny. Everything you're saying it's ironic because it's much the same as what I hear from injured workers. It's become, it's gone from a system where every time I hear Richard speaking, well, the WSIB should be helping the worker. They should be taking care of them, and they're not. And it's gone from that to that they're not helping them to, like you said, all about money. Like Trump says, money, money, money. And it's just purely, and it seems like, and that was one of the things with the what I call is forced return to work, is that the only thing they care about is getting that worker back to work so they don't have to pay them anything. And that's my big argument, frustration with the current system is if you're hurt today, the board will tell you to get back to work tomorrow so they don't have to pay any benefits. And it often worries me because, no, well, from the injured worker side, they can get re-injured. Okay, that's a problem. But then there's liability to the employer side. And I've talked to Richard about this is if I was an injured worker and I got hurt again, the board, in my view, would put it on the compensation system unfairly. Now, I'm not saying they do this. I'm just saying conceivably they would put it on your report and saying, well, it was work related, so it's on you. When it wasn't, it was really on them because they told the worker to go back to work. And you're saying no. And then there's the issue of other people getting injured by this person going back to work, like of customers or coworkers. There's this huge liability issue that I don't think the board has really sat down and thought thoroughly through, or am I wrong?
I don't experience your last comment there, where an injured worker coming back to work has caused somebody else to get injured. I haven't, at least I don't know if that's ever happened.
Mhm.
But yeah, the board likes in certain claims, not every claim. They love how we file it with like I was saying earlier, with the modified job already signed and accepted by the injured worker. And to Richard's last question there too, we all know that if a worker goes on loss of earnings with the board, they get 85% of their net.
Mhm.
So one of the reasons, or I guess, I don't take the long way around the barn usually, especially when I'm talking about WSIB and how the financial part works. We offer 100% of pre-injury wages while a worker's on modified duties. So I will explain this to the worker if they're confused about modified duties. I don't persuade them. I just tell them the truth. You decide to stay at home and the board allows loss of earnings, they're going to pay 85% of your net. I said, if you participate with us and cooperate in modified duties, early and safe return to work, we will pay you 100% of your pre-injury wage. And we do that even if they're on work hardening. If they're only working 2 hours a day or 4 hours a day, we make sure that there is no wage loss, and it is financially beneficial at the end of the day for the company. But it's just it's I don't know. The WSIB, like I was saying earlier, my biggest thing is it's almost like you want to go down there with a sign that says and walk back and forth on 200 Front Street saying, can somebody set precedents? Because they never deal with a claim the same way twice. You could have identical claims, identical injuries, and we've compared this before with other people I know in the industry, and the claim is dealt with totally different. I don't know if they do that
What
on
would be the
purpose.
two different streams that they walk on?
So, to give you an example, there was one where I had a soft tissue back injury. I knew somebody else in the industry that had a worker with a soft tissue back injury. Restrictions were almost identical. The eligibility adjudicator and case manager with my claim allowed the worker or approved the modified job we had offered, and that worker had to come back to work. And the other person I was speaking to in industry, they said, no, the return to work is not safe and suitable, and allowed LOE in that claim. I mean, if you're offering sedentary duties are sedentary duties, right?
Right.
And I know, and I've watched, and I've listened to some of the comments, even with your podcast here about modified duties being safe and suitable, obviously first, but then also like not demeaning to the worker. And some industries, it's hard. Okay, so I get restrictions that a worker can't bend, twist, lift, and can't walk on uneven ground. Okay, well, I deal with construction sites, right? So it's like now you've got a challenge of coming up with modified work. So I mean, a lot of times it's sedentary, sitting at a desk, going
See,
through
that's
paperwork.
where the system is broken because, in my opinion, then that's when the board could be saying, okay, don't worry about it, Bill. We'll take care of them. And you're not punished for it because of your workplace, because
Right.
it's not safe and it's not practical. And that's where workers and employers, I think, both agree that the system is flawed, where it really isn't helping the worker and it certainly isn't helping the employer. Like there's the cases where I can see where there's good employers where they're like, how can we help you? And I get that I sense that from you. And then of course there's bad ones. And I'm not interested in the bad ones. I'm interested in the system because you can't use bad examples of workers and employers to say the system doesn't work because that doesn't fly. You need good examples to say this is a good employer, but they're struggling with this worker saying this work really isn't safe for them in this area and the board is saying I have to give them some work and I have to do a make work project and that's ridiculous for the employer and for the worker.
Yeah.
At the 3 to 6 month mark of the claim, so let's assume it's a back strain, you're expecting resolution in 3 months, but some people have back claims in their 30s and they never recover, even if it has nothing to do with work. So at the 3 to 6 month mark, what are some of the problems you have with board case managers and return to work specialists that are particularly aggravating?
Huh. Oh boy. Return to work specialist. Let's start there. I would like to start off this topic by saying 5, 7, 10 years ago, there were some excellent return to work specialists working for the WSIB. I don't know where those people have gone. I wish they would come back. In the last 6 months to a year, the new ones that have replaced them, I would probably say 9 times out of 10 on a claim, when the case manager asks me if I would like to initiate return to work services, I say no.
What
Um,
what is it? Can I ask you, Bill, like you're saying, and you have a comparison of good and bad. Can you give some examples of what they're doing or what they're not doing? Is that
Yeah.
okay?
So this this kills me. So, and this I just recently went through this with an injured worker, long-term injured worker, about a month ago. On this particular claim, here's one thing I don't like. We had 5 different return to work specialists on the same claim. Right there, to me, that is just nonsense. But the really disturbing thing is this: a return to work specialist, once they get the claim, they call and discuss with the injured worker without us being present as the employer prior to the meetings. If you have a worker that is slightly disgruntled, they don't understand that what the WSIB really does. And then everybody kind of comes into the return to work meeting with a preconceived notion that the employer is bad. The modified duties are not suitable. And they start whispering into the ear of the injured worker about transition and training. So now, by the time we come into the meeting, they're already talking about not being safe and suitable, and transitioning the injured worker into retraining.
See, that
Um,
that bothers me because I've heard, and I believe what you're saying is true. I do, and I'm not questioning it. But from the worker perspective, I hear the same thing in the sense of the return to work specialist is having private meetings with the employer, saying the worker's bad. And as soon as when I heard that, I thought, that's not fair. It should be like in a court of law where the judge is not allowed to meet privately with one or the other side. And a famous case in Atlanta, Georgia. Do you know this one, Richard? It was some rapper. It was live on YouTube, and I was like, oh my God, the judge literally held the lawyer in contempt and took him away. He eventually was removed from the bench for his antics because he had a private meeting with the Crown, sorry, not Crown, district attorney and a witness to convince the witness to testify. Like, totally, you know what I mean? And that shows you that's the standard that the WSIB staff and everyone should be following. Not that, but I mean, like, that is unacceptable. And I do genuinely think that anything that's being done communication wise, it should be always in a meeting format. So that way both sides have an opportunity to hear everything and respond. As they say, procedural fairness, to know what's being said and have an opportunity to speak. I totally agree with you for both sides, it is a concern because going in there with this sense that you're a bad employer or a bad worker is not good.
Do you think the workers are getting the right medical treatment and guidance during this return to work process, say the 3 to 6 month mark?
no. I mean, I guess I wouldn't know. I mean, I guess I could take an educated guess at the percentage, yes versus no. I would say it's probably less than 50% on a good day. I think a lot of times what happens is with case managers looking and reviewing medical. At that point, it becomes a big secret uh, between the WSIB and the employers, anyways. The general practice is a case manager calls me, says we have updated medical information on worker X. And I'm like, okay, great. Can you send it to me? No. I can give you the restrictions over the phone. And I'm like, okay, you're going to give me restrictions over the phone. So I guess I have to what? Find a piece of paper and write them down. Why can't I just have the medical report? There shouldn't be a secret. I'm the employer. I'm trying to help the worker. And I've gone as far as offering third party medical and the board turning it down and actually telling the worker not to accept it, which I find to be terrible. Again, if the employer is willing to set up and pay for third party medical for testing or imaging or something, for the WSIB to tell the worker again in a private conversation not to accept it and to stay with the WSIB system, I I mean, I don't know. It's very frustrating on a daily basis that would go on. Where I thought we were all, whether it's you guys, the WSIB, or people like myself, I thought we were all just kind of trying to work together to help injured workers, but that
I
has been
always
lost.
tell my clients to tell their doctor if the board calls, if they want anything, tell them to tell the receptionist, put it in writing
Yeah.
because it eliminates that intimidating factor. So it seems to me, and I've come to this realization, the board is intentionally doing everything over the phone. And I don't, as a legal person, I'm sure Richard would agree. You know how lawyers always say, do it in writing. And now I really realize why. Because I could turn around and say to you, Bill, yeah, I'm the case manager, and yeah, their restrictions are no heavy lifting. And you're like, oh, okay. So then you put Richard to work. Actually, that would be mean because Richard's too old. Sorry, I had to do that dig at Richard. But seriously, you put Richard to work, and then it turns out his restrictions were no light lifting and I made a mistake, and you go, Paul, you lied to me. You said no heavy lifting. And I say, no, 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 I never said that. I said no light lifting. And unless you recorded that call or have proof, it's all verbal. So I would be totally opposed to doing anything verbal. And in today's modern society, and this is where I get really upset with the WSIB, because I deal with Manitoba and Alberta compensation boards, they do everything by email. So there's no reason why the case manager can't email you and say, "Hey, Bill, here's all the restrictions. Here's everything you need." And I'm shocked to hear that the board isn't willing to give, at a minimum, the medical information as far as restrictions go. In fact, it's a legal requirement in any human rights accommodation thing if the service provider, employer, requests it to say, we need to accommodate you and we want to do it right. You have the right to ask for that information. And like you said, the only caveat would be is you have to pay. And you're like, yeah, no problem. That's the legal system. That's the fair system. It's funny how,
Can I ask Bill, now we're towards the end of the podcast, which is what effect is the strike having on your day-to-day management of disability and work accidents?
Yeah. Well, the WSIB operates like the WSIB. I mean, so I guess it was about the 2 weeks prior to the strike, they changed the Form 7s. They came out with a totally new electronic system for employers to fill out a Form 7. It went from the traditional 3-page paper copy that you could fill out online and submit electronically. Now it's 9 pages. It
This is
doesn't
the
work.
employer's report of accident.
Correct. The fields have changed. The whole way of filling out a Form 7 now for employers has changed. The system wouldn't work for a week. So we're monitoring right now that we don't get fined because we did have a couple of claims that were on the cusp. So we got to watch for that. And then, of course, the WSIB goes on strike. So, I mean, moving forward into the future, I think it's going to affect us a lot.
One of the people who are on strike sent us an email saying that the WSIB is not monitoring the claims after they've been accepted.
That wouldn't surprise me. I mean,
Yeah,
if you're looking at right now, who would monitor them? I believe my understanding is the only people actually working there are like the higher up executive positions. Everybody else is locked out. I can't see an executive higher up person monitoring a claim. They probably putting it in a file folder somewhere.
so you haven't had any claims being allowed and you thought the faucet should be turned off.
Not as of yet, but I mean, hang on to your shorts, Richard. I mean, we can average in years past 30 claims a month in construction, depending on how busy and how many people we hire. I've seen us go through June, July, and August and have 90 claims. If that's the type of season we're going to have this year, I I'm going to take vacation. Because I don't know, it'll be a big mess, and even if they come back to work, it's going to be a big mess, and they're already behind months and months and months, and now
Bill,
yeah.
Bill, does the WSIB offer the Form 7 online, like as a PDF downloadable paper copy?
Oh no, that would be nice. So, so what you have to do now, I have a claim specialist who works underneath me. She has to set up an email to send to the board, and then the board gives her a passcode to allow her to fill out a Form 7, and the passcode expires within a 24-hour period. So, in other words, if my claim specialist filed a Form 7 this morning with the passcode they gave her, and she went to say check on the status of the claim tomorrow, she would have to send another email and get another passcode. It's very, very efficient.
Well, I'd like to thank Bill
Yeah.
and, of course, Paul and all who are watching for a very interesting episode.
Thanks, Bill.
Yeah, thank
And
you guys. It was nice. I enjoyed it.
I wish everyone well and see everyone next week.
All right, thank you. Have a
Thanks.
good day.
Bye, everyone.